Time to begin. Thanks again for joining us today, everyone. We're talking about the topic of the state of the Federal Communications Commission's authority in light of the Major Questions Doctrine. I'm Laura Stefani. I'm a partner in the communications group here at Venable. With me today is Craig Gilley, who's also a partner in the group, and Liz Reinhardt, one of our associates. The topic of discussion came up because of a recent Supreme Court case, West Virginia versus the EPA, that looked at the authority that that agency was given to act on a particular statute. And in doing so, the court, this new majority that we have on the Supreme Court, determined that the agency overreached its authority to act. And Liz will get into the ins and outs of that case shortly, but certainly there are major questions that case brought about in terms of whether it signals what the court is looking to do, whether it's going to look for more explicit grants of authority to agencies who require those. Whereas in the past, certainly, most of the time that Craig and I had been doing this line of work with Chevron, agencies that had much more leniency to act. So the decision has prompted quite a discussion, both within the regulatory groups here at Venable and amongst us, in considering how we might manage the work that we do before the Federal Communications Commission, both in how we advise clients, what type of advocacy we take, and obviously if we do take any action before a court for judicial review of the FCC's decision. And with the commission, we're talking about an agency that is looking at implementing rules for 21st century technologies to keep us where we're at and bring us to the future. And yet its major authorizing statute was enacted in the 1930s, almost 100 years ago. And some of that was based on statutes that were in place beforehand. And it hasn't had a major overhaul in more than 25 years. And so we have an agency that's using 20th century statute to try to focus on 21st century technologies and try to act quickly while it's doing that. So obviously we're thinking about how this EPA case and the Major Questions Doctrine, which was announced and adopted for the first time by the Supreme Court in that case, might impact what the FCC will do and how a court would look at the FCC.
Yeah, this is an issue that goes across all of administrative law. It hits all the agencies. It hits all the statutes that govern the agencies, authorize the agencies. It's, I don't want to say acute, but it's poignant in the FCC context because there's a tradition of giving the FCC, through either ancillary authority or through reading in between the lines of direct grants of authority to the commission, there's a tradition of granting the commission wide leeway. So, other than in the environmental context where a lot of this litigation will originate and decisions will originate, the FCC is sort of second in line, or we're right there, right behind it as a target, because a lot of what the FCC does and a lot of what we argue as communications lawyers and assume is that the FCC is sort of all powerful when it comes to wire and radio communications. This, just as with every other agency, calls that all into question and has impacts on the courts and on the agency itself and on parties that are before the agency or regulated by the agencies.
And I think it's going to take some time to shake out exactly how this is going to impact.
Yeah, it's definitely an earthquake that is going to have to be worked out through case law. And that'll be interesting to see how that plays out. And we'll have impacts on how our industries are regulated and how the agency regulates us, how the agency sees us as regulated parties.
Liz, do you want to give us some details about the case and what the court did, and then maybe we can talk about Chevron and how it impacts Chevron or not, and then the FCC.
Sure, definitely. Thank you, Laura, and thank you, Craig. So I'm not an environmental lawyer. I am going to do my best to just give a high-level view of the environmental issues that were decided in West Virginia v. EPA, and then sort of move on to the admin. The overarching issue that was before the court that the court decided was whether the EPA could promulgate regulations as part of its acknowledged authority to regulate emissions. They wanted to promulgate regulations that would cause not just a change in the way that regulated parties reduce their emissions, for example, by using certain cleaning mechanisms, but actually force those companies to shift towards cleaner fuels. So from coal to a cleaner energy source. And so the agency cited as its authority a provision that it had used before, but that it had never used in this manner. And I think that's one of the main themes to take away from both the Major Questions Doctrine and this case, which is if an agency starts finding unprecedented authority that is very far-reaching, the court is going to look very skeptically at that. And in fact, the court did and said, we're really not going to buy the idea that in the many, many years you've been in existence and that you've been doing this type of regulation, all of a sudden you found the ability to cause a seismic shift in the way energy is generated in this country. And so that's from that case's perspective what happened. But in doing so, the court recognized a line of cases that thus far in only academia have been called the Major Question Doctrine cases, and solidified them into the Major Question Doctrine and recognized that doctrine. And the foundation of it is a common theme that we find in administrative law, which is that an agency can only wield the power that Congress gives it. And Congress is expected to legislate and not give the agency the right to legislate, and not give the agency unfettered reign to make its regulations. And so it's not new in terms of concept, but it's new in terms of the court naming it and enforcing it and using it to invalidate an agency action.
Okay.
And so to answer your question about Chevron, obviously it's well known that the court, members of the court have their sights set on Chevron. They're not happy with it, particularly the level of deference that the case law has ended up giving agencies when applying Chevron. And as a very, very quick intro, basically when a court finds that a statute is not explicit in granting power to an agency, the Chevron doctrine comes in and allows the court to, or actually commands the court to defer to an agency's interpretation if that interpretation is reasonable. So the Major Questions Doctrine sort of cuts off that second step and says, we're not going to defer to you just because it's reasonable if this is going to be a major shift in the economic and political spectrum of our country.
If there's major questions.
Exactly. Congress has to be much more explicit. Right? Yeah.
Yeah, and this comes from a general skepticism, especially among conservative or right-leaning legal thinkers and scholars and people and legislators, frankly, that the agencies and administrative law have gone too far in favor of the agencies and agency taking aggressive action and really taken the legislative power away from Congress, and that Congress has actually been all too happy to let the agencies do the dirty work when it comes to policy. I think there's a lot of thinking that there needs to be tension between the legislative branch and the executive branch, and that with that tension gone, the pendulum is way too far in favor of the agencies. That all being said, there's a jurisprudential problem in that ever since the New Deal, something called the non-delegation doctrine has been basically a dead letter. No court really ever finds that Congress didn't delegate enough authority to the agency. So that leaves Chevron as the defense to an agency overstepping, and that too, especially people on the right, would say that jurisprudentially it's way too in favor of the agencies, that Chevron is basically almost not every case, but lots of cases, gives overarching deference to the agencies. So here, this is sort of trying to split the baby here. We're trying to come up with a new doctrine that fits in between, that limits, especially in terms of major agency action that impacts the economy or society in major ways, a way for courts to hold the agencies in check and get back some of that authority, tilt it back in favor of Congress. You actually hear people on the legal right say, Congress, you got to go do your job. You can't just give it all to the agency. So that's sort of more of the context of where this is all coming from. And again, it all needs to be fleshed out through case law and through cases and people bringing cases. And as they work up through the courts, the gaps will be filled. Right now, it's very amorphous.
Yeah, I was going to say, I think it's going to take, a decade plus for us to see where this shakes out. And so what that brings is kind of a lack of predictability, right? That's where a reviewing court is going to end up on one side or the other. We can kind of make some predictions based on what we know that certain circuits tend to do and others tend to sway other ways. And
isn't it correct that like there's cases going forward now, there's decisions that are out there where they're starting to play around with what this doctrine means, not in FCC context, but in other contexts. So
very much so, and unsurprisingly, there is a party line division, right? So we see courts that skew more conservative. So the 11th Circuit, the 5th Circuit are they're applying the case. They're not calling it the Major Questions Doctrine, but they are applying West Virginia as a way to narrow agency power as well as just the executive branch power. The 11th Circuit applied it to executive orders, which is, the dissent concurrence in that case was not happy to see that the doctrine was expanding. Similarly, the 5th Circuit applied it in the context of an individual order for a company. So kind of sidestepped the major question part of the Major Question Doctrine and just found that the agency had exceeded its authority. So I think it complements a trend that we're seeing of courts trying to resolve these cases based on just the language of the statute and, pardon the terrible pun, sidestepping Chevron.
And by its nature, it's highly political because it goes to what one thinks about the role of government in society, the role of government in the economy. It is how far should an agency be allowed to go? So you get this right-left political divide, and you will for the next, until this is resolved, probably forever as it is played with, because people on the left will want to protect the agencies and aggressive administrative action, and people on the right will want to push back and say agencies need to be reined in. So this is all going to come down on, it is at the core what you think about government and the role of government in society. So.
And the court didn't give a lot of direction to lower courts, did it?
Not really. It was not so far as like we'll know it when we see it kind of direction, but the examples they're giving, is it sweeping? Like, is it broad? Is it unprecedented? Well, there's a lot of things that are unprecedented and sweeping. That isn't a bright line, correct?
And that parlays into, the FCC, and what is most commonly talked about as sort of the first target regulation that would be the target. And that would be if the FCC were to get a full commission and bring back net neutrality, that one would be right in the sights of this because it is so sweeping. Internet and broadband is so ubiquitous and so important to our economy. And yet the authority that the commission is given is really vague. Trying to use Section 1, the ancillary jurisdiction or ancillary authority of the FCC, or trying to shoehorn it into Title II, those are things that are ripe for an attack. And but there'll be other instances and other regulations. But that's the one everyone's talking about. That's the one that comes to mind when you think, oh, this is a ripe example. But we'll see it in other places too. I think that almost every appeal where there isn't a really clear blanket, like direct authority to the commission to do something and they adopt a rule, as a litigant, you almost have to bring it up just to preserve it because you don't know, the panel that you get could
Right.
grab right onto it and off you go, and it could go to the Supreme Court, and we're not, but you have to argue it. So the appellate courts are going to have to wrestle with it because people in the FCC context and in every other agency rulemaking where there isn't a super clear delegation of authority, and that's frankly got to be 70% of the cases, this is going to come up.
Yeah, we have a question/comment that came in that says, hasn't net neutrality kind of been through the courts already, and haven't there already been judicial limits imposed on this authority? So will the Major Questions Doctrine really change the way courts could review FCC's a future FCC action on net neutrality?
I mean, there is a framework. I think this jumbles it up a little bit and adds a new argument to the pile. Whereas I think because you didn't see it before, you didn't see people making this argument because they didn't think it was live. Now you do. So I guess my first answer would be it depends on what the FCC does this time, how far they go. I suspect that they can't, because the world is so different, do what they did 12 years ago or 13, 14 years ago, the first time they tried this. They tried to impose net neutrality. And I'm sure that there will be parties or amici that will bring this up because it's just so perfect for this case.
Well, let's talk about what else that's on the FCC's plate that might be implicated. And I think we've kind of questioned whether a major question is a major question to be considered under the Major Question Doctrine. But what would be, amongst what the FCC deals with, what could fall under the category of major question?
My first reaction is once a party has decided to go and undertake appellate litigation against the agency and all the expense, all the emotion and energy that takes, I can guarantee you that they're going to say from their perspective that whatever question is teed up is a major question. Whether an objective observer would say that, probably not. Again, that adds fuel to the fire. As the lawyer writing the brief, you kind of get to serve your client both emotionally and for preserving arguments for later. Strategically, I would say you have to put it in, and it does. There'll be instances where it'll be a major part of the brief, and there'll be other instances where it'll be 3 sentences. But it's almost always going to be in there where there isn't an express delegation. Now, there's instances in the Communications Act, like Title VI, the cable rule, the cable laws. There are very specific delegations to the agency. You write rules that say this, do this.
Yeah.
I'm not talking about any of those, but maybe a slight majority of FCC rules are coming from less than clear delegations from Congress.
Yeah. I mean, I was thinking about orbital debris, right? The commission's going to come out with new orbital debris rules, and obviously it's a major issue. It's something that's important that needs to be addressed. The commission is kind of, for a very long time, attached grant of authority for a test satellite or permanent satellite authority to going through its orbital debris showing process and making this showing. But there's certainly nothing in the Communications Act that spells out, that the commission should require any satellite licensee to make a sufficient showing on the nature of the orbital debris that satellites may create. So you could argue that there's almost have no authority. I mean, the commission attaches its authority to give radio licenses to doing that. And they also kind of theorize that, well, if something were to happen, there was a collision in space, it would take out a satellite and take out the radio communications. That goes clearly to the FCC's authority. But is that even a Major Questions Doctrine question?
So I think it would certainly fall under the idea of, is it sweeping, right?
Mm-hmm.
But what I'm hearing is that it actually isn't particularly unprecedented. And so I think there would be it would be something of a crapshoot, whether the court would say, okay, it's sweeping enough that we're gonna forgive the fact that the agency's been doing it for quite some time, or we're gonna look at this and say, well, it's actually a little different than what you've been doing. But really what the doctrine, I guess, punishes is agency creativity. So if the agency can point to a sort of a precedent, a way in which they've always been doing this, and this is just a slight tweak, I think they can continue to expand and make these policy decisions. Although
That sounds like Skidmore.
well, and I think what'll happen is, because I think what's gonna happen naturally is the court's gonna become, if the composition stays the same, increasingly hostile to this type of deference. And so it won't be the major questions doctrine, it'll be the non-delegation doctrine will come back, which it sounds ridiculous, those words coming out of my mouth, but they don't want the deference anymore.
So there's a practical effect on the agency too, which is they're going to have to do a lot more work, especially if this takes root and grows. The agency is going to have to explain its authority much more directly. In the past, where parties or commenters in policymaking instances have brought up, not sure the agency has the jurisdiction, both parties on the other side and the agency have kind of given it a brush off. But here, I think to protect themselves, they're going to have to really start explaining the scope of their authority. And I think that to practice before the FCCM, it's more work there too. When you're advocating particular policy positions where there's ambiguity, you need to help the agency one way or the other, I guess hurt the agency. You need to explain in your briefs why or why not the authority is robust or ambiguous or not there.
And perhaps focus on the idea of consistency.
Yeah.
What you're asking for something is consistent.
I mean, it has always been the case since I've practiced since 27 years that when there was any ambiguity, you would just cite Section 1 of the Communications Act. It's the ancillary authority. There's this preamble language, and it covers everything. And if it touches wire or radio, then the FCC can do it. And I just don't think that is good enough. But the courts will help, will flesh that out. So it's in play.
Any other particular examples?
Is there a question there?
There is a question, yes. Do we see the major questions doctrine as merely removing Chevron authority when there's a major question, or also requiring a clear statement by Congress of such a delegation? In other words, is there now a clear statement rule for major questions?
Well, I think two things. One, it saves Chevron, I think, for a while, because Chevron is viewed skeptically. This provides an outlet for parties, for judges who are skeptical of a particular agency action where they don't have to knock down Chevron or say it doesn't apply. It provides another argument for parties and for judges and not have to go, to say that Chevron is dead or doesn't apply. So it saves it, I think, for maybe for 30 years until the winds change again.
Well, I mean, I'm a pragmatist. I feel like we were talking about this earlier, that if it's a serious national issue, national security type issue, I don't think a court is really going to pull authority out from under an agency and leave this huge regulatory gap on something really important. I mean, yes, you could argue that Congress should have stepped in and done something. I'm just not sure there's going to be a lot of judges willing to do that.
I know. I
kind of disagree.
Yeah, I really appreciate your optimism. and that's not to say that I think the judges would do it as that they wouldn't be cognizant of what they were doing and they wouldn't hesitate. But I think the people who believe that the administrative state has grown far beyond what it was ever meant to be think that this is a matter of, the soul of the nation, right? That it is part of their duty as judges to rein in this type of unfettered power and to make Congress do their job. And I think, absent, like you said, a national emergency type of situation. But I mean, we saw in, the vaccine cases where that was a national emergency, that was, an unprecedented situation, and the courts did not hesitate to strike them down. because there are principles that they're not willing to compromise
And I
on.
think if it all plays out such that major really is major, that the Major Questions Doctrine and Chevron do fit together. If major is used so wantonly that it's just like, and so randomly,
like it.
it's just, we
Right.
don't like this particular policy choice, so we're gonna apply the Major Questions Doctrine, then you really start to interfere with Chevron. It's a really delicate dance, and it'll, provide administrative law professors article fodder forever, but
I'm already seeing some start to come out.
yeah. So it strikes at the heart of constitutional law and administrative law, and, but it has real world impacts on agencies like the FCC.
Right, for sure. Okay. Let's see if there was a question about the Prometheus decision. What does the Prometheus decision tell us about SCOTUS deference to the FCC's authority?
I'm gonna pass on that one.
Yes, I'm honestly not sure. I apologize. The person that asked the question, I would love to follow up with you afterwards. I can certainly say as a general matter that the recent decisions of the Supreme Court looking at agency authority have been very focused on statutory text.
Yeah, I think we're in a new.
They want to avoid deference for as long as they can.
Yeah, I think we're in a new world here too. Is not just in this area, but obviously abortion rights and the Supreme Court is different than it was 2 years ago, and this is one of them. And it's going to play out, and we can talk about precedent. I think that what the circuit courts and the Supreme Court do going forward, I think there's going to be a lot of precedent that's overturned or skirted or ignored.
Right. And I guess then the other question is, well, is Congress going to do more, right? Either just generally or specific to the FCC's authority, where I personally have thought that the act is long overdue for an update, and is this going to cause a new Congress to take action? I mean, I think I'm more skeptical in that sense.
Well, I mean, not only take action, but they have to take very explicit action, right? So,
Yeah.
I mean, one of the reasons that there was deference to begin with was because the courts recognized that neither the courts nor Congress wanted to get into the weeds, and that these agencies had expertise. Depending on how explicit we're requiring these commands to be, that's, that efficiency isn't going to be there anymore.
Great. We are coming up at the end of our half hour. Does anyone have
Another question at all, or we doing our?
Nope.
Okay.
So thanks everyone for joining us, and please be in touch if you have any questions or want to talk about these issues in detail. We certainly have been talking about them, as you can tell, internally quite a lot, and we are all interested to see where this is going to take us.